Good afternoon and welcome to this NZIOB webinar. My name is Malcolm Fleming, Chief Executive of the Institute. The NZIOB is pleased to welcome back Janine Stewart and Stephen Price for today's webinar, both of whom are Construction Division partners at Minter Ellison Rudd Watts. As I mentioned last time, Janine is also a member of the Construction Sector Accord, which is a group that has been very energetic and effective since the threat of COVID-19 first emerged. This is the second COVID-19 themed contracts webinar that we have run with Minter Ellison Rudd Watts. The first one occurred earlier in the month at a time when gaining good guidance about the status of the contract for works stopped by the government's COVID-19 alert level 4 announcement was desperately required. As an example of the fast moving environment at that time, our first contracts webinar fell on the same day that the MBIE's Chief Executive sent a guidance note to government agency CEOs stating that in regard to construction projects that agencies might have in progress, the government's response to COVID-19 had resulted in an effective change in law. The government's view was welcomed by industry with the hope that the government's leadership on this issue would flow through private sector projects. Given the diversity of the NZIOB membership base, half of whom are employed by main contractors and the other half being design consultants, project managers, consultants, suppliers or clients, it was important to us that an NZIOB webinar on contracts be one that provided a balanced view on this topic. This is important also to Minter Ellison Rudd Watts. Also, as Janine and Stephen said to me after the first webinar, they are representing a principal one meeting, a contract to the next, and while the firm also undertakes a good amount of work with consultants also. One of the takeaways for me from the previous contracts webinar was Stephen's comment that it may be a little bit unusual for a lawyer to say this, but let's not get too hung up on the contract. Stephen's message was effectively that both parties should take a pragmatic approach to moving the project forward rather than a contractual approach. On that theme, I see that one of the discussion items on today's webinar description is prevalence of pragmatic versus contract outcomes. I'm looking forward to gaining understanding how that has been playing out over the last few weeks. Today's webinar will be broken down into two components. Firstly, a review of the key issues that came up over the 4-week lockdown period. And two, what are the issues that may arise as the industry restarts under level 3? An example of that being, how is the loss of site productivity that is a consequence of additional health and safety compliance dealt with? Before I hand over to Janine and Stephen, I'd like to make you aware of the NZIOB's upcoming COVID-19 themed webinars. Next Wednesday, we'll be running our third wellbeing webinar, which sees Kyle McWilliams return with a webinar titled Back to Site, or Not Back to Normal. The webinar occurs the day after construction sites reopen. So we'll be sending all those registrants a 45-second survey the evening before and asking them, what are the key issues that you faced on day one of your return to work? That feedback will inform the webinar material that Kyle covers. We've just been discussing, just prior to coming on to this webinar, that with Janine and Stephen, a potential third contracts webinar with Minter Ellison Rudd Watts, which we target at consultants specifically. Looking at doing that in 2 weeks' time, when we'll push out the advisement through the usual NZIOB communication channels. So enjoy today's webinar. Please ask the question through the platform's Q&A function. I will return after the presentation to present those questions to Janine and Stephen. So finally, I would like to acknowledge the support of JIB, the NZIOB's national partner, without whose assistance we would be unable to bring you today's event. So handing over to you, Janine and Stephen.
Thank you, Malcolm, and thank you everyone for joining us again. It's hard to believe that we've gone through 2 weeks and that we're actually in a position to say, well, what's actually happened with these contractual issues, and we are now looking at remobilising rather than facing another 2 weeks of level 4 lockdown. I was listening in on the Accord yesterday, and it was really encouraging to hear that the focus for MBIE and government is really on resetting and revitalising the construction sector. And that's a really positive message, and it's great to be able to bring that through into these webinars as well. One of the other key takeaways that I had from that session was that somebody said something like, wouldn't it just be great if all the lawyers could agree? And I think that's quite an interesting takeaway, given the number of views that are out there in the market on the key issues that are arising. And I think, as Malcolm said, we acknowledge that this is a very stressful time for everybody in the market, for contractors, for subcontractors, and for clients, particularly in my experience, private clients who are facing the difficult decisions on whether to continue with their projects, looking at their project's viability, and also contractors that are having to make difficult decisions as to whether it's more cost effective for them to go back to work or remain in lockdown. And those are all really difficult issues. So we acknowledge the stress that is out there. And as Malcolm said, we do, I've spoken in the past 2 weeks to subcontractors, contractors, clients, and consultants. So we do understand the perspectives of all, and we do our best to give what we see as the legal view of the contract and also some pragmatic ways forward. But it's very rare that you're ever going to get an absolute black and white answer. And I think you should be wary of being told that there is one. But to that end, I'll just turn to the slide which sets out what we're going to cover off today for you. And I thought it would be helpful with Stephen to go through the review of the progress of the key issues that we discussed last time. You know, what did happen to suspension? Did we see suspensions being actioned following negotiation after the seminar and other webinars that have dealt with the issue, or did we see more of a focus on change of law variations so parties could stop fighting about suspension and actually agree on a change of law? And then we're also going to run through some of the issues that we think are going to arise for the remobilisation of projects. And that will include the cost of compliance. That was a big issue raised at the Accord yesterday. And my understanding from that is that there will be some government guidance issued either later next week or soon thereafter in relation to the treatment of those costs. So I'm sure that will be welcomed, and you should definitely be watching that space. But to that end, we'll turn to our first topic, which is on the next slide, which is really a review of what happened to the issues we were discussing. I think I've seen some interesting progress. As I said at the last seminar, a number of clients agreed to a mutually agreed suspension and excluded the variation provision and the termination provision of 3910, but agreed to discuss and pay contractors' costs on a reasonable basis. But that was very much about negotiating what those costs would be and acknowledging that in the private sector, principals were also suffering as well, and this wasn't something that was either of their faults. So I've seen that happen. I've also seen some changes in payment terms, both in terms of the timeframes within which payment claims and payment schedules would be served under contracts and payment would be made. I've seen advance payments, but from principals to contractors, but on express terms that would flow down to the supply chain and flow down to subcontractors, because obviously if the subcontractors aren't paid, then the project doesn't have a long-term viability prospect either. And now I'll turn to Stephen about what you have been seeing in terms of how parties are treating the contractual issues and really the lockdown period.
Thanks, Janine. What I've seen in the last couple of weeks actually has been, I won't quite say an avoidance of the contract, but I have seen a real rise in trying to reach a pragmatic approach. So I've been seeing parties not trying to rely on suspension. I think that was an initial knee-jerk reaction from some, and perhaps worth a try for some, but I haven't seen that at all really in the last 2 weeks. I have seen, like you said, the suggestions of an agreed suspension rather than treating it as a variation. I'm certainly seeing a lot more focus on the change of law provisions under 3910 and other contracts, although with a clear lack of agreement about what that means in terms of recoverability of costs, and that's something which is being pushed down the track. But what I've seen, which is perhaps a bit consistent with my suggestion a couple of weeks ago, that people should be focusing on the project, not the contract, is I have seen parties wanting to know what the contract means for them, but then, I won't say disregarding it, but I will say looking past it, being particularly focused on relationships, focused on what's going to be happening at the next step, possibly recognising the resolution now and some cash flow now might be a better solution than actually having to try and fight for something further down the track. So I've seen perhaps a very unlawyerly approach to things, and that's possibly a positive thing. Obviously, there's some industry guidance coming out of government, but that's perhaps more binding on government bodies than on private bodies who will feel potentially aggrieved by some of those views. But what I am seeing are parties looking past it, and I think that's going to be very helpful for the time being, even if it's nothing more than looking past it in terms of an agreement on what to do now, with a determination on what it means down the track. And that to me has been positive.
I've had some experience where, despite the government's guidance note, which has been welcomed, there's been a few cases where one size doesn't fit all. For example, where the relationships between the parties are strong and the project has had a fairly smooth run in terms of being reasonably on time and on budget, I have seen a lot more collaboration than where, for example, there's been really tense or adversarial relationship between the contractor and the principal. And I wonder if that's a behavioural aspect, but I have seen in those cases parties taking more of a contractual approach. Have you?
Yes, I think that's a very fair point, and I've got some clients who've been taking different approaches in different projects for that very reason. I think it's been a certain amount of you reap what you sow on this. So some of the parties where they've been very difficult along the way through the project, where they've perhaps taken every point and they haven't been as collaborative as they otherwise might have been, are now finding that might be coming back to bite them a little bit. Where the parties that I've seen who have been getting along throughout the contract and been approaching things in a more collaborative way through the project are now in a position of collaboration at this point in time. So I think it's an interesting picture that goes far beyond just COVID-19, but for any issue, the commercialities of things sometimes are secondary to behaviours that happens along the way.
Yes, I think that's a fair comment. I think I said last time that I had been working with some Australian lawyers who had been examining the issues under their contracts, appreciating that they weren't locked down, and their standard form does have a force majeure clause. And I wondered whether the fact that our standard form doesn't has meant that we have had potentially more contentious issues arising than we otherwise would have. For example, is there a suspension or isn't there a suspension? Whereas if the contract had dealt specifically with a force majeure event, we may not have had those initial disputes.
I think that's right to some extent. Obviously, there are provisions in 3910 that address various unforeseen circumstances. The reason I say it's right to some extent, though, is that I'm also involved in a number of other matters where there are force majeure terms in the contract. So we're not dealing with 3910, or sometimes dealing with 3910 with some additional provisions. The existence of the force majeure clauses in those cases, they're not removing the scope for disagreement, they're just making the scope for disagreement a little bit different. What does constitute a force majeure event? What is the consequence? We're having a bit of arguments about whether to be a force majeure event, it's got to be something that is stopping you from doing work, such as a lockdown. But where do you get to if it's going to be an impact rather than a prevention? It may well be harder, more expensive, less productive for the contractor to do something. Whether that falls within the threshold of a force majeure event is something which I know they're having issues with over in Australia, and which we are certainly seeing in other projects. So I think it's a matter of, rather than solving the problem, it just makes the tension looking a little bit different.
I'm really interested if there are, and there will be, subcontractors on the seminar to hear comments about how they're seeing contractual issues treated, because I think our last seminar focused very much on principal and contractor, whereas obviously, as I said, the supply chain and the viability of projects very much depends on cash flowing down through to subcontractors. How are you seeing that going in the market?
I think people are largely ignoring the subcontractors. I don't think that's a good thing. I think they're ignoring them because they're possibly just a little bit too hard to think about. If you have a contractor on a project, they are thinking about themselves and the project. And if they've got a dozen odd subcontractors, then it might be in the too hard basket. I haven't seen a lot of noise around the subcontractors. I am seeing some principals taking the position that you said, which is very understandable, which is it's all well and good to be resolving something with the head contractor, but particularly nowadays where the head contractor might be doing less and less work and largely having the work done by the subcontractor, that might solve an immediate issue. It's not going to solve the full project issue. I think that subcontractors actually need to be more involved and be noisier, because I don't think they are getting the attention. And if they're not getting the attention, then the contractor might be resolving things for themselves to some extent, but not downstream in relation to the subcontractors. So I think it's going to be an interesting position to see how these subcontractors are coping. They'll be the ones that will be very much suffering, and without them, the projects cannot be completed. So I'd be encouraging contractors and principals to be thinking about the subcontractors, but also the subcontractors need to be out there and having a greater presence. We haven't seen them having the level of presence I thought we would.
I think that's a fair comment, because whilst a lot of subcontractors tie into the head contract and adopt the 3910 provisions, they also have very special and often onerous terms. So it would be helpful to have more about that in the market, and that's something I've certainly thought about.
But even looking past the terms of the contracts and going back down to the good of the project, and that's something which I can't emphasise enough, is that it's not going to do anyone any good having a project that's ultimately not finished, but people have managed to enforce their strict legal rights, because at the end of the day, the best way of devaluing a piece of land is to half build on it. So the reality of it is it's necessary to look past the specific terms. Unquestionably, many of the subcontract terms will be onerous. We still see that, unfortunately. The real issue is going to be if the subcontractors aren't considered, if they're not looked after, then when we get to the new level of normal, whatever that might be, if they're not there to finish the works, then the project's going to hit other obstacles.
Yeah, I think that's fair. We've had some discussion about the scope of MBIE's guideline and essentially what guidance it gave in terms of suspension and in terms of change of law. And my interpretation of that document, and I'm interested in your views as well, is that it acknowledged that in some cases engineers had suspended and advised parties of their rights to a variation if that was the case, and then very clearly said that in the government's view there has been a change of law which entitles parties to a variation and time under 3910. I don't read it as saying that the fact of a change of law creates a suspension. Would you agree with that?
Well, it's certain. I've heard all sorts of positions advanced on it. I've been amazed at the level of emotional reaction to a lot of these issues, perhaps not surprising given the effect it has on livelihoods. I've had people pointing that document saying, look, it says suspension, and other people pointing to the same document and saying, look, it says change of law, not suspension. So I think it's important to come at it from two ways. The first part of it is I read it as simply a recognition that there had been some grants of suspension or treatment of suspension in some cases. I saw it as a guidance to particularly government bodies that it ought to be considered as a change of law. But at the end of the day, it's not got legal effect. So if one was going to stand in front of an adjudicator, an arbitrator, or a court, and then point to that document and treat it as some sort of legal precedent, it would, from my perspective, have absolutely zero value from a legal precedent perspective. So I think it's important not to get too hung up on it. I imagine that most government bodies will be heavily influenced by it because they'd probably get a certain level of grief if they didn't. But realistically, it is not legally binding on principals, contractors or subcontractors. So however people wish to interpret it and advance it, to me ultimately is interesting, but the real question is, what does the contract actually say? And applying the usual legal tests to it, what's the correct interpretation of the contract? If one's looking at it from a pragmatic commercial perspective, I actually don't particularly disagree with the concept that it's probably not a suspension, but it probably is a change of law, and it's a matter of working out a resolution that is shaped around that. But that's more of a commercial, pragmatic view than necessarily all the ins and outs of arguments about what is or what is not the correct legal interpretation of contracts.
And my view of it is that the real message behind it is let's keep the industry going. We don't want to drive anyone into the ground. And if you know, we all need to be working on the long-term viability of projects and parties. And as I said, for the private clients that I've been dealing with, where they already have had that objective, the note has been welcomed. But where there is a contentious relationship, it has been more difficult. And whilst it's offered some guidance, it's not necessarily going to be the answer to everybody's problems, but it's certainly a great leadership position to have taken in terms of let's try and get this project done and everybody wins.
I think it's helpful for a conversation. I think where it's being unhelpful is where someone has taken it and tried to shove it down the other side's throat as being a legal precedent, because that's led to more entrenched views from what I've seen, as opposed to it being a good basis for a conversation.
Okay. We had some discussion last night when we were preparing for this about whether we're seeing claims being made by contractors yet for the costs themselves, and what sorts of costs are being claimed under the contract. I've had a couple of examples where there's been some helpful addressing of the sort of causation element of, you know, we are claiming a change of law variation, this has caused us to incur these costs and they're claimable under the contract because. And I think that framework has really helped the parties. I've had a couple of difficult examples for, in one instance, we had to assess a claim where the contractor was claiming for costs during lockdown, obviously for payment of employees, and had also received the government subsidy scheme. So in my view, that's potentially a double recovery, and I think that caused some issues. What would your view on that be?
Well, it does get difficult because there's going to be clear arguments about the effect of causation. Let's assume that we're in change of law territory. Let's assume we treat it as a variation. There's going to be arguments about which costs relate to the change in law and which costs relate to the virus. The virus is not a variation. The change of law would be a variation. Certainly questions that you're talking about there from a double recovery perspective would be troubling. That doesn't look like a good example. I have seen some examples already where the contractor has basically treated it as if it was a wholesale breach of contract by the principal and wants to charge as if it was a full wasted month at full rates, essentially an indemnity against loss of profits. I don't think that's helpful either. I have seen at the other extreme principals behaving just as badly and taking the position that it's all the contractor risk and they'll give some time, but they won't entertain any other considerations. So there's obviously quite a diverse range of views. I have also seen some builders and principals, I think like you, taking a very sensible approach about what is the appropriate sort of delta between or difference between the positions and a certain level of compensation for the downtime or for costs. Certainly for time-related costs have been, that's been a bit more open to discussion, which I think is sensible. I think that there could be a lot of argument about what falls within the causation link of change of law versus virus versus other things. I think it's going to be a matter where there can be a lot of argument for it, a lot of costs incurred in relation to it. They're more likely going to be resolved by sensible discussion along the way. But I imagine at some point in time we're going to have to see adjudications and potentially arbitrations and maybe even court decisions dealing with some of those things, which will give a level of certainty at that point. But right now it's really just a matter of trying to work out what's going to be a sensible resolution.
Mm. Yeah, and I think that's the final bullet point, which we've canvassed quite well in terms of the prevalence of pragmatic versus contract outcomes. And if I step back and look at over the last month, and sort of draw a line in the sand and say, at this point, what am I seeing more? And I'd have to say, I am seeing more pragmatism than strict contract adherence. And in some cases where it's more difficult to be pragmatic or to put the issues with the relationship to one side, I'm seeing parties sort of work through a parallel process of continuing to have commercial discussions, but working through the contract as well, because obviously that's what you have left if you don't have the relationship to bring you together. So I think in the end, I agree with you. I've seen more pragmatism than strict contract, but there is a middle ground as well.
Well, I think an important part of that right now is if a contractor came to me and said, I want to enforce my full cost recovery, I would say I'm very happy to pursue that for you. Probably the fastest way for doing that is going to be through an adjudication, and you're probably going to go through a process. It's going to take about 3 or so months by the time we prepared the claim, got the response, and had the adjudication decision out. And you'll either be happy at the outcome or you'll be unhappy at the outcome. But what you do know is over the next 3 months, this project's going to not perform in an optimal way. If a principal came to me to say, I don't want to pay anything and it's all the contractor's fault, my advice would be remarkably similar, which is we'll go through a 3-month process for an adjudication and there'll be a result and you might be happy with it or you might not, but in the next 3 months, it's not going to be a particularly optimal working environment. So I think it's very important that people understand that right now there are bigger problems than who's in the right or who's in the wrong. Getting the cash flow working, whether that's as an advance payment, whether it's a payment, reserving rights, all sorts of things like that must be the focus right now. And I think what we're going to see will be the projects that survive and manage will be those that are dealt with in that mature way. The projects which have people taking entrenched and contested positions are more likely to hit grief, hit strife. I do recognise that for some principals, contractors and subcontractors, they will be having to choose between a failure of their business or the project and an extreme position. So it's not going to be quite as simplistic as we'd like it to be. A contractor who is out of money and is going to otherwise fail may well be left with no choice but to take an extreme position, likewise for a principal. So there's many drivers in there, but what we do know is if there's going to be a fight and a contest about it, it's going to take some months to resolve.
I think that's a fair comment. Just before we move on, another issue, cash flow has obviously been a major concern over the past month, and the government's guidance note and the NZIOB guidelines proposed solutions to that I went through. One of the solutions was the early release of retentions, and I have seen a couple of examples where there's been a partial release, and the concern from principals has been obviously the lack of security, and I imagine that would flow through from the lenders as well. Can you see a solution to that? If we are releasing retentions to get cash flowing, I know there's been discussions about potential bonds, but bonding capacity is going to be very difficult at the moment as well. So I wondered if you'd had to grapple with this issue.
We have had to look at it. We haven't found an easy solution at all. You end up with two competing tensions from a downstream perspective, whether it's a contractor or a subcontractor. Cash is king. They've got bills to pay, they've got people to pay. They've probably been able to carve out a decent chunk of their costs to some extent, but they've still got a lot of costs to pay. It's very important for that cash flow. The difficulty is that the reason that cash flow is so necessary is because construction companies and subcontractors don't tend to have a lot of working capital on hand. They tend to be pretty much working month to month on their cash flow. So what that really does mean is that increasing cash flow ahead of the work that has been done actually start putting the increased risk on the principal, and the principal is going to be conscious of that. You make the point, no matter how generous the principal might be, the principal's lenders are going to be very wary of that right now. So that's going to be the biggest tension, is keeping up the cash flow is great if you can count on the fact that the contract is going to be there in 3 months' time. But the reason you're having to increase the cash flow is because there will be a number of distressed parties, and that increases the risk that you'll pay money and they won't be there in 3 months' time.
Or they'll find a more attractive project, which was the initial reason for suspension in for retentions in the first place. But I have seen some solutions, as I said as well, potentially creating separable portions by agreement so that retentions can be released on a pro rata basis is another potential to get cash flowing. I suppose the other thing is if the principal is releasing retentions to the head contractor, where subcontractor works are at a point where it's sensible to release them, it doesn't really work as a principal unless it flows all the way down.
Yeah. And at the end of the day, the retention structure under 3910 is not particularly generous for large projects.
All right, moving on to our next topic, which is really the remobilisation of the sector. And in the discussions that I've been part of, I think there's much, and Malcolm was just saying as well in terms of the seminar yesterday, there's much to be learned from how essential projects have been operating in terms of how construction sites work under a strict compliance regime, much stricter even than the new Health and Safety at Work Act from 2015. But I also was concerned to hear that some subcontractors are so concerned about the cost of compliance that they consider it's actually worth their while staying under lockdown rather than working under alert level 3. I think this is a real issue that could cause project delays and potential jeopardise projects generally. And so I think there are some issues here in terms of, we know that alert level 3 is going to have requirements, including social distancing, and essentially if you can work from home, you should work from home. So for example, if project management and consultant arrangements that would have been done on site can now be done from home, it must be. And then there's also the new Health and Safety standard version 1.1 that is now on Chasn's website and is essentially being seen as the benchmark for health and safety standards on construction sites for alert level 2 and up. Have you had some thoughts about how those costs are going to be addressed under the contract?
Yes, we've been having to look at it fairly hard, and there's a wide range of views, unsurprisingly. There's also a lot of uncertainty because it's still not clear whether some of the things that we're having to look at are direction or directive in nature, guidance in nature, regulatory in nature, and all of those things have quite different impacts. And I'll explain that a bit better, is that if you're dealing with an impact on a project, and let's be frank in this, unquestionably, whatever the world is going to look like from next Tuesday for construction, it's going to be one that's going to take longer and it's going to cost more. There's going to be a clear impact on productivity and a clear impact on the timing of delivery. So let's treat timing cost as a given. The question in terms of who's going to bear which parts of the risk and which parts of the cost, and it may not be a same answer for everything, under 3910 it's going to be quite dependent upon the source, if you like, or the cause of the impact. If there was a piece of legislation or regulation that came out and said you must work in this way, then the impact of that regulation would squarely, I believe, fall within change of law. If instead what comes out is something that says, here are our expectations on what it's going to look like, but it's something short of a regulation, you're going to have to then try and link it into the change of law arguments that we discussed last time about whether it's linked to the Orders in Council making COVID-19 a quarantinable disease under the Health Act. And you need to try and access it that way. If it is guidance related, if it is something that says you have health and safety obligations and here's what we see you need to do to comply with them as a result of the virus, then that's going to be very hard to link to a change of law. So those are the sort of three different ways. And you can imagine that principals are going to want to argue more for the latter and contractors are going to want to argue more for the former. And there's going to be some uncertainty around it. But even if we land on a situation that says certainly some of the changes are flowing from something that is attributable to a change in law, that doesn't mean that all costs are going to flow under that. So it's going to be something to be relatively complicated. I am concerned to hear about people saying that they are choosing not to return to site because it's going to be too expensive for them. I don't think that's a particularly safe approach to take, because a party who has a contract and is therefore obliged to do work and is not physically prevented from doing the work doesn't really have an excuse for refusing to turn up. If it's going to cost them more and that's their risk, then they've still just got to do it and they'll be in breach. If it's going to cost them more and that's claimable from upstream, the head contractor or the principal, that still doesn't enable the person to refuse to go to work. So whilst that might be an understandable reaction, I think it becomes very hard at alert level 3 to take that position. Obviously, alert level 4 is a lot easier because they were prevented. At alert level 3, it becomes a matter of decision to not turn up. And if you could have turned up and you're not prevented by the law, you're actually acting in breach of contract. So that's going to be where it becomes quite a hairy issue for parties in that situation who may have very good reasons as to why they don't want to turn up. They might have situations where some of their staff actually are vulnerable, and how to deal with that from a workplace perspective. So there are many issues that will arise. It's not just a matter of being something you can scratch the surface on, but it's going to be clearly not a black and white answer, and the answer is probably going to be some costs are recoverable, some costs are not, and the issue will be identification as to which fall within which category.
And I think an early discussion on that would be most beneficial, especially if contractors, putting whether it would be a breach of contract to one side, are struggling with the ability to come back to work and to have the cash flow to actually do the work. And so I know that in the Vertical Leaders Forum, they are encouraging discussions on that front. And I think early discussions around how to classify costs, what they might look like, and even how to deal with them on an interim basis would be ideal. And where relationships aren't at their best, having someone independent come in to facilitate those discussions can go a long way, rather than just resorting right back to contractual dispute processes.
Well, people are very quick to point to the contract, and obviously 3910 has a dispute resolution process involving the engineer and the ability to refer off to mediation and the like. That does not preclude people agreeing or choosing to actually go through other processes on top of that as well. And we don't see mediation used outside the scope of the strict wording of 3910 very often, but it's something which is often used in different forms in other contracts. The inclusion of an independent person to be able to be involved, or whether it's a dispute resolution board under certain contracts or things like that, we might see the rise of that opportunity where parties can still continue for the good of the project, but in a way that's going to also enable the principal to survive, the contractor and subcontractors to survive as well.
I think that's a good point, and I know we are saving questions to the end, but it's so relevant right now that there's been a question about whether, what happens if it's the client that says, actually, I'm not going to start the project, and the project's closed, we won't start again until alert level 2. I would have thought, unless there was a suspension or a suspension at the sole discretion of the client, then that could equally raise contractual issues.
Well, and in that way, it's no different from a client that just says, actually, I've chosen to put my project on hold for a couple of months. They can do that. They can issue a suspension notice, but they're likely to bear some pretty significant cost consequences as a result.
And I suppose if they haven't done that, then there may well be an argument for a deemed suspension.
I just thought so.
Mm.
I mean, what we are seeing, I mean, it's amazing because we wouldn't have thought we'd have this conversation 4 weeks ago, but what we are seeing is a return to site, the lifting of a lockdown, and I won't say a return to normal, but certainly the return to a new normal, which will be that the works can continue. Bearing in mind, overseas in Australia, they've continued on with the works. We've been very strict in our lockdown approach to construction, so we know that physically the work can be carried out in a safe and effective way. We're going to have to think what that looks like, both in terms of the pragmatic aspects of it, the health and safety aspects of it, but also what that means for the project part of it, because it would be unwise, I think, to assume that we're going to return to a 2019 state of affairs on site within the next month or so.
I was just thinking about some of the other issues that could come up, and the distinction between delay, disruption, acceleration, and all those great issues. You know, some of the suggestions, well, guidance in the health and safety guidance note is create zones in the construction site. Other suggestions have been having contractors working in shifts. Now, you could structure your site so that, within reason, depending on how large the site is, that you have more contractors on the site, but you've spent the money to create zones. Or the contractor could say, well, actually, I'm going to opt for shifts because that's the best way I see to comply it, which obviously then prolongs the project. And those decisions in and of themselves are commercial, aren't they? Because it's what route you take under the contract.
Well, yes, although it gives rise to a very real question about mitigation. And that's something which I suspect is going to end up being thrown around quite a lot over the following few months. I'm sure that there are, from a construction consultant's perspective, there are various ways that you can choose to skin that particular cat. Whether it's shifts, whether it's zones, whether it's all sorts of things. I don't even pretend to be an expert on the way you might choose to build a building in different ways. Each of those will carry different cost consequences, and I can imagine a contractor saying, we've done this, we think it's a reasonable reaction, it may have cost a lot more money, but it meant we can do these other things. I can imagine the principal saying, I don't think you have mitigated the costs appropriately, and you can see that as being a tension down the track. Obviously, some amount of doing that in consultation together might help to some extent, but I think that there's a real opportunity for actually some very clever consultants to work out the best ways of now approaching this project in a different environment.
I think it's fair. We were talking yesterday about the health and safety standard and what legal effect that has, and I think that the present view is that the Health and Safety at Work Act has not changed. The guidelines that have been issued create a standard, so to speak, that may well be and is likely to be referred to by WorkSafe when they are considering health and safety compliance on site. And I do know that the government will be looking to WorkSafe to enforce health and safety measures, although there are also measures that can be taken under the Health Act. I think it's section 71A, to enforce compliance with protocols that have been issued pursuant to the Health Act. So it's going to be interesting to see how the enforcement process is going to work.
I think that enforcement is one part of it. That ties into the question about which party is going to bear the risk. Because if it is simply a guidance note where the WorkSafe is going to say, here's what we'd expect of you, you could view that as being no different to a situation where there's been a prosecution through the courts, and as a result of that prosecution, the parties in an industry say, gosh, we better change some of our practices to make sure we don't fall within that now clarified position. That's not a change in law, that's an application of the existing law. That's to be compared with if what we are seeing coming out is going to be Health Act notices saying you must do it this way or you're breaching the Health Act, then yes, that will likely move back to the change in law. I suspect that the government's going to be more focused on the WorkSafe part of it for a number of reasons. One, it's an existing process and something that they're familiar with. But the other part of it as well is it will probably provide a bit more discretion in that it doesn't mean everything's got to be done in the same way. It can provide a certain level of discretion about whether for a particular project, maybe something different can be done.
Yeah, I think that's fair. I think it's probably timely. I've seen there are a lot of questions coming through to turn over to Malcolm to run through the questions, unless you have anything else that you want to add, Stephen.
No, I think that's everything. I'm happy to see where we get to with some of these questions. Hopefully they won't be like last time we were being told that we're being too principal friendly and too contractor friendly at the same time.
No, it's a good range here. A couple that come through. Well, there's a couple of comments here just that I can answer regarding the timing of the webinars. We've moved to 12 o'clock for the new webinars. This one was already scheduled at 1 o'clock, but from next week on, they'll be at 12 o'clock. Right. Someone here has been asking the question, have you seen anything since the last webinar that changes your previous view that the cost of people at home and who are unable to work on the project is not a variation cost?
I'll answer that one to start off by saying I don't think my previous view was that it's not a variation cost. My previous view is that it's probably not a suspension, but it might fit within a change of law, and how you then calculate that's going to have, or the impact of that's going to have quite a lot of argument. So it's not, my view hasn't changed, if that's what the question is in there. But where it is going to get down to is if you've got people at home and unable to work, is that a cost which fits within the scope of clause 5.11.10, I think it is, or is it not? If it is a suspension cost, then you're more likely to be able to claim it as being the equivalent of downtime. It's going to depend very much on the circumstances and on the application of clause 5.11.10.
There's a couple in here also in regard to materials on site and any deterioration or damages to those materials during lockdown. Who carries the cost of the repair? And actually, just before Stephen or Janine answer that, I noticed that Brains have got some guidelines that they pushed out yesterday, which we carried in our NZIOB dispatch.
Well, Janine, do you want to answer your views on that one?
I think it does come down to whether there's been a suspension or not, because if there has been a suspension, I think it would be arguable that costs relating to the suspension, including deterioration on site, would fall on the principal. But I suppose if you get a variation for a change of law, and as a result of the change of law, you couldn't go to work and maintain that equipment, then arguably that would be a cost as well.
I think that's possibly right. From what I saw, there was enough warning generally for quite a lot of protective measures to be made before the sites went into lockdown. And I am also aware that there have been some maintenance securing type works continuing on a number of the projects I've been involved in as part of the essential services still. So I don't know the extent to which that hasn't happened on particular projects, and if so, who to blame. Without even pretending to be an insurance lawyer, I imagine that trying to recover it from insurance is going to be quite a difficult one, not just because insurers don't like paying money, but also I imagine that they'll be trying to rely on various force majeure and pandemic type exclusions as well. So there may well be some arguments on that. But I think it's going to be important to look back to see who was basically responsible for protecting the site during that time and whether there's been a failure on either party's part.
Yeah.
There's a comment in here from a consultant. This is quite an interesting comment in terms of continuing the theme of government goodwill. This consultant saying the Ministry of Education is releasing retentions on projects that they're running currently prior to practical completion, but have had some conditions, including releasing intentions to subcontractors. Janine, probably through the cord, you might know something about that.
Other than the guidance note, which was endorsed by the Accord, which encouraged release of retentions, I haven't been privy to major discussions on that. That doesn't mean it hasn't happened, it just might not have been on one of the ones I was on.
In most 3910 contracts, there are provisions for a working day rate to cover the cost of extensions of time. Now, that's a main contractor daily rate. Is this rate deemed to cover the subcontractor delay costs? Is a question.
I might let Janine answer that one.
Well, I'm just trying to get my head around the question. So
that's why I handed it over to you.
Yeah, so I think the question is, does the day rate cover, is it meant to be a blanket rate that covers anything that comes through that is claimed by the subcontractor as well? And look, every contract will be determined on its terms, but you know, the principal's relationship is with the contractor and the agreed costs are with the contractor. And so unless there's a specific provision that says that those costs are in addition to what the contractor is going to claim, I would have thought it was a catch-all. We've had that issue previously, if you're dealing with time-related costs and working day rates, that they are meant to cover what your expectations are from the subcontractors as well, unless you're getting costs in through from the subcontractor that relate to matters that weren't foreseeable, or there is some wiggle room around the clause.
I've got a couple of questions here from a head contractor who's been asking subcontractors or suppliers to order for the project items on long lead times, which are in transit, and the contractor is receiving an invoice for part payment of those goods, even though they can't be normally not on site. Any interpretation of that? This question is, what's the best way to address that and ensure the security of the materials is with the principal or head contractor who's paid the deposit?
Well, I have a couple of comments on that. The first thing is that's a very sensible and proactive approach being taken by a head contractor. The lead times on projects does concern me in relation to some of the approaches taken. The risk of arguments about a failure to mitigate are almost certainly going to come out of it. And bearing in mind that it's not just normal long lead times, but they're presently pretty much wherever you're bringing things in, it's even longer lead times, whether it's overseas or otherwise. So I think it's a very sensible course of action. It does raise a very obvious question about who's going to be able to fund those in the meantime. I think what you've identified there is a contractual mechanism which would not see those funded in the meantime from upstream, and yet very good reason as to why it would be in the principal's interest to have them funded so as to ensure it going on. That seems to me that a head contractor who decides to take that sensible approach without talking to the principal runs the risk of being told contractually they're not entitled to be paid for it. But you would also think from a pragmatic perspective, any principal thinking about the good of their project would want to come to different arrangements.
What are your views on claims for personnel, and would these expected as long as the cost claimed is reflective of wage subsidy and reduction of full-time equivalent percentage paid at 80% of normal salary?
Well, this gets a tricky one because this comes down to who's bearing the costs and how's it to be allocated. So that question suggests to me that what's being asked, well, it's starting from the premise that says that the principal should essentially be indemnifying the contractor for the effect of the lockdown. And that's obviously a matter which in itself is going to be extensively argued. If the answer to that is ultimately found to be yes, then it must surely be a net cost situation, because otherwise it would be similar to a contractor claiming for costs under a variation but failing to disclose they had a 20% discount applied or something like that. which would mean you'd end up with claiming more than costs. It's net cost, you'd be claiming more than net cost.
Yeah.
But I think it's important to start from the position of actually query whether that amount is correctly payable. That is, of course, the million-dollar question that no one's going to be able to land an answer on. And so the question number one has to be, is the contractor entitled to be indemnified as a result of the lockdown?
Here's a question that doesn't relate to 3910. It says all references are made to NZ 3910, but how of all of this, how does this apply when a contract is an NZIA conditions of contract?
Come to our next seminar.
Good answer.
It relates to 3910 because that's been the mandate of what we've been discussing on this. And I don't have NZIA conditions up in front of me, and it's going to be very specific. Each wording specific. If you're under NZIA, if you're under FIDIC, if you're under NEC, whichever form you're under. The answer always has to be, you need to look at the contract to understand what the contractual arrangements are. So we've been dealing with that under 3910, and so I guess my answer is going to be, one, have a look at the contract to be working out your correct legal answer. But then point number two is, as we've said at the start of the webinar, that's what the legal answer will be. Now you'll have to think in terms of the commercialities and the pragmatic positions separate to that, and so that's not going to be dependent on the contract at all, because at the end of the day you're better off having a project that's completed and a contractor that remains in business than being in the right but being either out of business or out of project.
Okay. This is probably as night follows day question, but what about future new contracts? Will we see pandemic clauses being introduced?
Well, I've already got some which do have pandemic clauses in them, actually. And then it comes down to interpretation of those. Oh, look, I think the reality of it is all lawyers will learn from past events, and not to say that 3910 or other contracts are failing by not referring to pandemics, and they deal with things in their own ways and their own allocations. The reality of it, though, is that as something becomes front and centre, then you're going to think about it more in the future. There's a point in time in history where construction contracts, as a matter of standard provision, will refer to terrorist acts or to nuclear events and things like that. It's the sort of thing we may well see it either come in explicitly or potentially come in a way that more explicitly captures events, whether it's a pandemic or other similar things.
Or perhaps a greater focus on how the contract deals with the risk of unforeseeable events generally. And some contracts that are bespoke do that, but obviously by and large the standard form doesn't. And I think some clarity around a clause that deals with cost allocation for that, because at the moment all we have is time under clause 10 of NZS 3910. And also there are some questions around this, what costs are recoverable. It would be helpful to have some clauses that deal with that. Generally when we're dealing with disputes, we look at things like foreseeability, whether it's a direct or a consequential loss associated with damage, whereas when you're in the midst of a project, you are dealing with whether increased costs are recoverable and what increased costs are recoverable, and we need to have a think about how we put some parameters about that.
Okay, well, we're just about a minute or two to go, so that sort of probably wraps us up really. Thank you very much, Janine and Stephen. It's been wonderful to have you again, and it was good to see that a non-main contractor looking for some information as well. So that was sort of a nice little segue into our next webinar, which will be consultants focused in about 2 weeks' time. So we'll start working on that one.
Thank you.
Yeah, so once again, hope you enjoyed the webinar, and that's it. Thanks very much.